talk about an extradition matter that's grabbing headlines. South African Justice Department today says it has studied and it welcomes the judgment by the High Court in Malawi regarding the extradition hearing of Pastor Shepherd Bushiri and his wife. Now, the court has ruled that South African officials will have to go to Malawi to testify. This is overturning an earlier ruling that witnesses in South Africa could testify virtually. However, the Justice Department is also concerned about some misinterpretations of that judgment from Malawi. Just a bit of background, of course, in 2020, Bushiri and his wife Mary arrested in Pretoria on charges of fraud and corruption. They skipped the country in violation of their bail. I'm joined now by Justice Ministry spokesperson Chrispin Phiri. Chrispin, thank you so much for joining us. Before we get chatting, I actually want to play just a clip of an interview I did with the Bushiri's lawyer. And it's specifically relating, earlier on in the interview, he said to me, we're only interested in South African officials. You know, that's who we'll be speaking to. That's who will appear at the extradition hearing. And then later on, he acknowledged that the 10 rape allegations, depending on what's in the docket, they may well want to call these women to Malawi. It seemed to contradict what he'd said earlier to me. So let's take a listen to that, and then we can chat about what your department has said today.
It is in the interest of my client that he faces those women who are putting forward rape allegations against him. With regard to what the court has said, the witness statements of those rape victims are still needed in court. It's not like the court has said the investigator should just tell us what has investigated. No. The witness statements themselves, duly authenticated, are required in court, and we have the right to cross-examine on those witness statements. How we'll handle that cross-examination of the witness statements which the investigators are going to bring to Malawi is an issue which we don't want to cross the bridge now.
All right, so he did go on to say, and I questioned him at length, but he did acknowledge that if that were the case, he would want those women in Malawi. Just explain to me, from the position of the Justice Ministry, is it your understanding that that might become an eventuality even in the extradition hearing?
Good evening, Sally, and good evening to our viewers at home. Certainly the judgment on page 12 specifically, in the judge's own words, he makes it quite clear, and he says that in relation to any other witness, there is no need for them to be presented to Malawi. There's no need for them to come. So the issue of them being protected or them experiencing some form of victimization doesn't arise. The judge says that there was no need for them to come to Malawi. At the heart of this judgment was what are the relevant witnesses which were required to appear before the Malawian authorities. And this judgment clarifies that the relevant witnesses are agents of the state or representatives of the state, as it says in some instances, or people with intimate knowledge of the investigation that's at play. And they are required to answer specific questions in terms of Section 6 of the Extradition Act in Malawi. But most importantly, the judgment also really draws in a very important distinction to say that this is not a trial within a trial. An extradition hearing is completely different to any other matter that would be presented before the court. So this is not a criminal process before another criminal process. And at first, maybe when seeing some of the headlines that most of our colleagues had put out, one of the things that we did think was that, is this possible that the Malawian authorities actually want actual witnesses in a criminal trial to appear in Malawi and testify? And the judgment makes it quite clear that they do not want the witnesses of a criminal trial. That would be that would be a trial in and of itself, and they're not interested in that type of a matter. What they want is people who have intimate knowledge of the investigation itself to appear.
And I would imagine that that extradition hearing and those officials will have to put their case on why it is crucially important that the Bushiris stand trial in South Africa. What sort of evidence at this stage do they have to produce?
Sally. So it's not that they would have to put their case, but there are specific questions that the court had outlined that speak to the Malawian Extradition Act. One of those questions was to ensure that this matter is not a politically charged matter. So you are not politically pursuing it, it's not a political persecution of sorts. And I think there are three specific questions which the court had highlighted, and I've shared the judgment with colleagues to see. But those questions are not at the heart of the case or go to the merits of the case. But they are to ensure that indeed there's going to be a fair trial. There has been a fair investigation in place, and people will be given an opportunity to answer to these allegations in a forum that is non-judgmental, in a forum that is free, and a forum where their freedoms are guaranteed. And that is mainly what the South African courts are about. Our South African courts in the main are spaces where people are able to be held accountable, and you would, at the end of the day, after presenting your case, be found guilty or not guilty. But that the process here is so that these people are brought back so that they can answer to a credible case. And the Malawian authorities want to understand indeed whether this is a case that is well ventilated within our own systems.
So the Bushiris claim that their lives were at risk in South Africa, that there were a number of assassination attempts. Also, they're claiming extortion attempts by South African officials. How are you planning to deal with that? Because I would imagine that is something that has to be addressed, because that sounds like it's going to be the main basis of their argument for not coming back here.
Well, I think that's a matter that's going to be before the courts, and I wouldn't want to preempt what some of the parties are arguing or what the fugitives are arguing. The relevant officials and experts who are seized with the matter have more than the capacity to deal with such allegations, and they will be able to confront those allegations in the relevant forum, which is the court. And the judicial officer will have to assess whether indeed there's merit behind the claims of extortion, etc. But safe to say that we think that is a matter that will present itself in court, and at this point it would not even be appropriate for someone who represents the executive to comment on such issues.
So Wapura Kita last night says that his client says he's innocent, and he also believes that no witnesses will come forward to testify against him. Can you confirm for us, to your knowledge, whether the state has got a case with witnesses prepared to testify in it?
What I can confirm, and I think this is public knowledge, there is a case before our magistrate courts currently. There were charges that were presented in the magistrate courts, and individuals were then subsequently given bail because they had to come and answer to those charges. It was believed that these individuals would be able to present themselves to court. These individuals chose not to present themselves to court to answer these charges, but they have escaped and gone to a foreign jurisdiction. And that is how we are where we are today. So the question of whether someone is innocent or not, the opportunity was presented to this individual to come and answer for themselves in court, and they've chosen to abscond. And this is where we are. So once again, I can't confirm what the docket looks like. I can't confirm who's going to be a witness, who should be a witness. We believe that our law enforcement agencies are very competent and they've done their due diligence. That's why the matter was actually presented to court in the first place. And they will be able to bring more information to a judicial officer, credible information through our law of evidence procedures to ensure that whatever is alleged in that doc can be substantiated beyond a reasonable doubt as required by a criminal law standard.
I was able to establish from their lawyer last night that the Bushiris are not under house arrest in Malawi. In fact, Shepherd Bushiri is running a church in Malawi. Is the South African Justice Department comfortable with a fraud and possibly rape-accused pastor and a fugitive from justice living so freely in Malawi?
What is important is that the individual appears at the hearings where he's required to appear, and we receive high levels of cooperation from the Malawi government thus far, and I think that is what is relevant to us currently. How they choose to curtail the individual's freedoms is a matter within their jurisdiction, and it would not be appropriate for us to really opine on that. But what we would want to see is the continued high levels of cooperation. When the individual has been required to present himself to court for an extradition hearing, the individual has been presented. And thus far, that really speaks to high levels of cooperation, that the Malawian state is able to ensure that this individual is hauled before the court for this particular hearing.
Is the extradition hearing set down yet? I understand not yet, but have you any update on that?
Maybe let's to say on the previous point, the optics of it, of course, I think maybe would appear to be concerning to some individuals, but like I would state, for us, the measurement is the levels of cooperation that we are seeing from the Malawian government. The extradition hearing has not been set back to the chief magistrate. We await the Malawian authorities' advice on that.
All right, thank you so much for chatting to us, Justice Ministry spokesperson Chrispin Phiri there. Do stay with us, plenty more to come. We're wrapping your news of the day.